Legal dictation start. The Honorable Supreme Court had observed that while entertaining the appeal on 6/8/2009, this court had framed substantial question of law full stop. However, while deciding the appeal, finally that substantial question of law has not been adverted to at all full stop. Hence, the matter was remanded to this court for disposal of the appeal based on substantial question of law framed earlier, after hearing both the sides full stop. This is how the present appeal is before this court full stop para. Before proceeding further, it is apposite to note that while admitting the present appeal, this court had culled out the substantial question of law as follows para. Whether the jurisdiction of the civil court is barred in terms of section 5/50 of the Haryana Urban Development Authority Act, 1977 question mark para. While arguing the appeal, learned counsel for the defendants appellants have submitted that since prescribed notices, as contemplated under section 17 of the Hooda Act, had been served upon the plaintiffs, therefore, the prescribed procedure has been followed by the authorities full stop. It is his further argument that the plaintiffs had availed statutory remedy of appeal full stop. Order passed by the statutory authorities have been declared to be final by section 50 of the Hooda Act full stop. The courts would not set in appeal over the orders passed by the statutory authorities full stop. Hence, the suit of the plaintiffs was not maintainable full stop. The jurisdiction of the civil court stood excluded by section 50 of the Hooda Act full stop. To substantiate his point, learned counsel has relied upon the decision of this court rendered in RSA number 2317 of 2009, titled as The Estate Officer and Another versus Parveen Kumar, decided on 17/9/2009 full stop. Hence, he prayed for allowing for the appeal full stop para. On the other hand, learned senior counsel appearing for the plaintiffs, respondents has submitted that since the defendant Hooda had been wrongly insisting upon payment of the amounts along with 18% compound interest, therefore, the demand itself was beyond the authority of the defendants full stop. Therefore, notices issued by defendant number 2 were in excess of their authority and so in violation of the procedure prescribed by the law full stop. It is further argued by him that, even the notices issued by defendant are totally stereotype, issued in a mechanical manner, without disclosing anything as to the details of payment on account of principal and the interest components full stop. Learned counsel has also argued that, bare fact that the defendants had shown a stop